Thank you. All right, Ms. Smith, can you hear us? All right, let's try this again. We are on the record with 2022 CV 365689, Georgia Farm Bureau Mutual Insurance Company versus Wade, Wood, Wilson, and Grumberg as the collective defendants. And we have our court reporter joining us remotely. And let's identify the parties now for the record, starting with the plaintiff.
Spencer Woody for Georgia Farm Bureau, Your Honor.
Ibrahim Reyes on behalf of Mr. Wood.
John Exum on behalf of Mr. Wood.
And Linda Brown on behalf of Nicole Wade, Jonathan Grumberg, and Taylor Wilson.
All right. And earlier when we had some discussion about the necessity for a court reporter, it appeared that Mr. Woody on behalf of the plaintiff was waiving that. And so, Mr. Reyes, you're agreeing to cover the entire cost of the court reporter for this hearing?
No, we discussed that we would split it.
Oh, I understand. With Ms. Brown?
Your Honor, we agreed to split it with them just to try to get somebody out here. So that's absolutely fine with us. We were just doing that in the sense of trying to get something going forward today.
Okay. So just so we're all clear and it doesn't cause confusion later, is it a third, a third, a third?
Yes, Your Honor. Yes, sir.
Okay. All right. And then just to make sure I've covered all the housekeeping, do we need to make it clear whether the clients themselves have waived their appearance, just for the record as well? Maybe that's more of a criminal aspect, but was Mr. Wood intending to be here? Are we waiting on anybody else to be here?
We're not waiting on anybody.
Okay.
Your Honor, my clients will not be appearing today.
Got it. All right, then. So we are here on the plaintiff's motion for summary judgment and received and reviewed the responses filed. There was also one filed yesterday by Mr. Reyes. And so my thought is to give each party about 20 minutes to go through their arguments and a few questions here and there on it. And Mr. Wood, if you'd like to kick it off.
Yes, Your Honor. Good morning, Your Honor. As I said, my name is Spencer Woody. I represent Georgia Farm Bureau Mutual Insurance Company in this declaratory judgment action. Your Honor, the purpose of this declaratory judgment action is to determine whether 4 insurance policies that were issued to defendant Wood provide coverage for an underlying lawsuit that was made against him from the Wade, Grumberg, and Wilson defendants, who I refer to as the WGW defendants. In that underlying lawsuit, the WGW defendants are suing Mr. Wood for 19 defamatory statements that he posted on his social media account on Telegram, which is like Facebook or Instagram. To give some backdrop and some background on how we got to this point and the relationship between the WGW defendants and Mr. Wood, prior to February of 2020, defendant Wood and the WGW defendants worked together as attorneys at Mr. Wood's firm, L. Lynn Wood PC. And sometime around February of 2020, there was a falling out, and the WGW defendants believed that they could no longer work with Mr. Wood. To separate them out, there were several business disputes that had to be resolved, including splitting fees for cases that had been resolved by the firm, and also splitting up liabilities in terms of lease agreements that were part of the business firm as well. To resolve those business disputes, the WGW defendants and Mr. Wood entered into an agreement on March 17th of 2020, which required defendant Wood to make certain payments to the WGW defendants on those fee splitting issues later on. Eventually, when Mr. Wood failed to make those payments, the WGW defendants threatened litigation to enforce that settlement agreement and ultimately sued Mr. Wood in a first action for breach of that settlement agreement. But in addition to that, after that lawsuit had already been filed, Mr. Wood took to his Telegram account between May 12th of 2021 and June 18th of 2021 and made 19 statements about the WGW defendants and essentially said that they were criminals and extortionists. And I've marked this as Exhibit A, Your Honor. I'll show it to the court and let me hand them out to the defendants as well.
It's contained in your brief in support, right?
Yes, Your Honor. It's actually paragraph 68 of our amended complaint.
All right. So do we need to make it a separate exhibit for the record if it's already part of the record?
It does not need to be, Your Honor. I was doing it out of convenience. The court already has it in front of it, and that's absolutely fine. But what this is, Your Honor, and the court can see it, is it's the listing out of all the defamatory statements for which Mr. Wood's being sued for in the underlying case. And you can see by just reading just a few of them, you can see that it's clearly a claim against the WGW defendants, calling them extortionists and criminals. Excuse me. Because of those remarks, he was sued for defamation in an underlying case, he being Mr. Wood. And as a result of that defamation claim, Mr. Wood turned around and made a claim for coverage under his Georgia Farm Bureau policies that he has with Georgia Farm Bureau. That leads us to the question today, is whether those defamatory comments are covered or coverage is provided for those allegations being made against him in the underlying complaint. He's made a claim, Mr. Wood has made a claim for coverage under 4 different policies, like I mentioned before. 3 of them are homeowners policies, and 1 is a personal auto policy.
Does Georgia Farm Bureau have other policies covering Mr. Wood or his business at the time?
I believe those are the only policies that would be in place during this period of time. These are renewed policies, so they do get renewed, but this is the only policies that fit within the timeline of the allegations being made against him in the underlying case.
And what was the motivation for the amended declaratory judgment about a year later?
Your Honor, we amended the declaratory judgment because we realized that the timeline for the policies that was originally filed was for the slightly off. It was the year before was when those policies were. So it would have been the wrong coverage period. So we amended the declaratory judgment action to put in the correct policies that had the correct coverage period, but it's essentially the same coverage language.
And what would be your understanding if as I understand it, the statements kind of intersect? Some of them happen before some of them happen while the policy is in effect, and some of them happen after. Do I have that right?
Your Honor, I think all of the statements between May and June of 2021 fit within the coverage periods of all the homeowners policies, except for 1, because that coverage policy was canceled by Mr. Wood prior to these defamatory statements, which would have been the homeowner policy number 3125762. That was a property cut providing coverage for a property in Greensboro, which was canceled before Mr. Wood made these defamatory statements, which is another reason why that policy does not provide coverage in this case. But the other ones, I believe, do fit within the coverage periods for the policies that are attached to our mini complaint.
Okay. Well, I guess what I'm getting at, so there may be at least one statement that is beyond the policy coverage period.
It may be, Your Honor. I would have to look and see and double check. I'd have to go back and look at all the 19 statements. I think if it was outside that period, I'd have to see if there was another policy to see if there was coverage on it, but it would be the same language on these homeowners policies as it would be for another homeowners policy, presumably.
Okay.
Your Honor, because these 19 defamatory statements are not covered by any of the policies that Mr. Woods made a claim for coverage under, Georgia Farm Bureau filed this declaratory judgment action that we're here about today. And then we filed a motion for summary judgment. Importantly, Mr. Wood is the only defendant in this case who believes that there is coverage under any of these policies. The WGW defendants agree with us that the initial coverage language, at least, of all these policies does not provide coverage to Mr. Wood. So it is essentially Mr. Wood's the only person saying that these claims fall within the coverage language of the policies. When courts are asked to determine whether an allegation, an online complaint fits within the coverage language of a policy, it tends to apply a 2-part analytical framework. And the first part of that is to ask whether the allegations of the underlying complaint fit within the initial coverage language. And it's important in these kind of cases, it is the insured's burden to show that the allegations fit within the coverage language. If the court determines that the allegations don't fit within the coverage language, then the court can stop its inquiry there and determine that there is no coverage under the policy and grant summary judgment. If the court continued on its inquiry, they could go to the second part of that analytical framework, which is to ask whether there is an exception that it precludes coverage under the policies. And in that case, it'd be Georgia Farm Bureau's burden to show that exception applies. If we take this analytical framework and apply it to each of these policies, we'll see that the allegations of defamation don't fit within the initial coverage language, and they're also excluded by a few exclusions in each of the policies. Starting with the 3 homeowners policies, as I mentioned before, Your Honor, they all have different policy periods, but they have all the same policy coverage language. For purposes of just making it simple, I'll refer to them all collectively as the homeowners policies. If we look at what the initial coverage language is under those homeowners policies, we could see that the policies only provide coverage for defendant Wood for claims made against him because of 1, bodily injury, and 2, that are caused by an occurrence. And those terms, bodily injury and occurrence, are defined terms in the policy. Bodily injury is defined as bodily harm, sickness, or disease, including required care, loss of services, and death that results. Occurrence is defined as an accident. And these are not unique definitions. There's nothing unique about Georgia Farm Bureau's use of these words. These are words that are used in almost a lot of insurance policies. The courts are very familiar with defining these terms and what they mean. So the question becomes, is the allegations of defamation in the underlying case a claim for bodily injury? And the answer to that question is no. The courts have determined that bodily injury it does not include non-physical, emotional, or mental injury. The Court of Appeals and Nationwide Mutual Insurance Company versus Summers made this clear when it said that as used in an insurance policy, the term bodily injury means just that, bodily injury. It pertains to physical injury to the body. It does not include non-physical, emotional, or mental harm. There's several cases that we cite in our reply brief that continues to show that is true. In other words, claims for emotional, reputational, mental harm are not covered within the terms of bodily injury. Here, the allegations against Mr. Wood and the damages that are being claimed by the WGW defendants are for emotional, mental, and reputational harm. There's nothing physical or bodily about the allegations being made against him in the underlying case. Since that's the case, there is no allegation of bodily injury, and there's no coverage under the initial coverage language for the homeowners policies. And this court could then stop its inquiry there and determine that these policies do not provide coverage for defendant Wood. If the court wanted to go on, it could then look to the second part of that initial coverage language, which is that occurrence language. Like bodily injury, the allegations of defamation in the underlying case are not an occurrence in this case. Occurrence is defined in the policies as an accident, and Georgia courts have defined the term accident as it's commonly understood, which, as the court said in Perry versus State Farm, Fire and Casualty Insurance Company, quote, an accident refers to an unexpected happening rather than one happening through intent or design. Acts could not be unexpected unless they were accidental. Importantly, Your Honor, the focus here is on the act itself. It's whether the act itself was an accident. It does not matter.
And is a finding for the purposes of that accident under the definition of occurrence, is that more along the lines of a voluntary act rather than getting into the area of the exclusion of the intentional act finding? Are those seen as separate and distinct?
I'm sorry, Your Honor, can you repeat that question?
So we have the intentional act exclusion, right?
Mhm.
And so does that bleed into the analysis for what is considered an accident under the policy coverage, kind of the first half of the analysis?
Your Honor, I think they're two separate things. I think the occurrence language and the accident language, asking whether something is an accident, looks at the act itself. The intentional act exclusion looks to whether the insured intended a result of their actions. So one is whether they intended to act, the other is whether they intended the consequences or could have expected the consequences of their actions.
So essentially, you believe that a finding on whether something was an accident doesn't have any bearing on the exclusion issue?
Not as the language in the policy reads, Your Honor. And I'll kind of explain that maybe a little more. We can maybe come back to it. But I think the key distinction to maybe answer your question as best I can in a nutshell is that when we're looking at this original coverage language on whether something's an occurrence in an accident, we're asking whether the insured intended to act, not necessarily the consequences of their action. For example, if I threw a football over a fence and I meant to throw the football over the fence, I may not have intended for it to hit my neighbor. Or
in the exclusion issue, that's looking more at the result.
That's looking more at the result. That would be whether I could have expected that I would have hit somebody on the other side or would have ruined the prize azaleas in my neighbor's garden.
So I want to make sure we use some of your time to, since you didn't get an opportunity to address kind of the supplemental response.
Yes, Your Honor.
Any thoughts there? I think it kind of relies almost entirely on the facility and investments case.
Yes, Your
And
Honor.
do we see that has some connection to a summary judgment, or what would be your response to the?
Your Honor, I've had only a short amount of time to really review it. I've had less than 24 hours, and I've tried my best to read into it and get the law on it. But my understanding of the argument is not one really dealing with whether there's coverage under the policy. It's whether the reservation of rights was sufficient to Mr. Wood, and whether there was a waiver of at any point of any sort of defense that Georgia Farm Bureau had. That's how I interpret the argument that's being made in that supplemental brief. And to answer that question, I don't believe that the portions of that Richmond case, that side, the Richmond and the Fidelity case, show a true reflection of what the entire law is when it comes to the sufficiency of reservation of rights letters and what's required for an insurance company to set up before defending someone under a reservation of rights. I think if the court continued on reading that Richmond case that's cited, I read it last night, it shows that the actions by Georgia Farm Bureau and cases like this is exactly what the court's okay with. I also think that quote about being prejudiced, it's not the kind of prejudice that Mr. Wood is saying in this kind of case where it's prejudicial because they've had their defense removed. That's always going to be an issue in a declaratory judgment action. They could always run the risk of having their defense removed. And that's something that was stated specifically to Mr. Wood in his reservation of rights letter, which I think is attached as Exhibit 6 to our amended complaint. What that's talking about, in my understanding of the law, is making sure that they're not prejudiced and not having an answer filed on their behalf or they go into default. Additionally, Your Honor, I think that rule that's just cut out of the Richmond case only applies if Mr. Wood objected to being defended under a reservation of rights. And I don't see any evidence that there was an objection from Mr. Wood being defended under a reservation of rights. He received a reservation of rights on April 1st. And 2 days later, he seems to agree to have Mr. Chris Harrison with Downey and Cleveland provide him a defense. And he signs on with Mr. Harrison 2 days later to file a defensive pleading in the underlying action. So I don't see where that would necessarily apply in this case. Again, Your Honor, I've only had less than 24 hours to really review it. And if the court would like me to, I could supplement and try to find a way to address it. But I don't believe that has any bearing on whether there's coverage in this case. And I also don't believe that it is evidence that there was a waiver of any sort of rights and responsibilities or waiver of any defenses that Georgia Farm Bureau had in this case.
And just for the record, and again, maybe as a matter of housekeeping, any objection, I guess they asked for a judicial notice of the motion to stay in the docket in the federal case. Any issues of whether that is not an accurate reflection of the federal docket?
Your Honor, I have not had the opportunity to review it and compare it to the actual docket. I have no reason right now to think that it's wrong. But I haven't had a chance to look and compare what they printed off and attached to what the actual docket says. I'm not going to assume that they did something that it's not correct, but I couldn't tell you immediately that it is correct.
Okay. And let me just butt in here, Ms. Brown, any same question?
Your Honor, I did briefly compare it, and to me, it looks like it's an accurate representation of what was filed in the federal defamation case.
All right. So just for purposes of the record, I'll say that the request for judicial notice is granted on that point with, the ability, Mr. Woody, if you need to file a motion or have any concerns after this hearing before the final order, you can.
Okay.
All right. But the bottom line was in the amount of time you've had to review this facility investments case, that had more to do with, I think it also had something to do with the recoupment of funds, right?
It was a different kind of case, a very different procedural posture where an insured, I read the case yesterday, where an insured and insurance company disagreed on what things were covered and what things were not covered under a policy. And when there was that disagreement, the insurance company ended up settling the entire case and then turned around and tried to get from the insured proceeds for the things that they claimed were not covered. So it's a very different procedural posture than what we're dealing with here. I think the focus would be back towards the Richmond case, which I think is a good case to outline. I mean, it's 1976, but it's a good starting point to look at what the rights and what requirements there are for a reservation of rights letter to be adequate. But Your Honor, the courts have consistently held that if an insurance company sends their insured a reservation of rights, files an answer timely, defends them throughout the litigation, and have that reservation of rights letter gives them adequate notice of the issues that are going to be dealt with at a declaratory judgment action, and the fact that they run the risk of having to put up their own defense at any point if the court decides that the declaratory judgment action is favorable to the insurance company. And the courts have said that's completely fine. The test there that's excerpted from Richmond is about fairness. And courts have said it is fair to do exactly what Georgia Farm Bureau has done in this case, which was give Mr. Wood notice that we're defending him under reservation rights, then provide him that defense, and then continue on with this declaratory judgment action like we are here today to determine whether or not it has a duty to defend or indemnify. So, Your Honor, if we kind of go back, and I don't want to spend too much time on this, I think the court has it pretty well understood in the briefs, but it's not a bodily injury. It's not an occurrence because it's not an accident. And the reason it's not an accident is because the court can look to what Mr. Wood's responses to our request for admissions were, which is paragraphs 44, 45, and 46 of his responses to Georgia Farm Bureau's request for admissions. And he's asked, please admit that you or someone acting on your behalf posted or published the 19 defamatory statements. He admits that. He says, please admit that you intended to publish or post the 19 statements found in paragraph 68 of Georgia Farm Bureau's verified complaint, which are those defamatory statements. He admits that. And 46, please admit that you did not accidentally publish or post the 19 defamatory statements found in paragraph 68. He admits that. Mr. Wood has admitted that he did not accidentally make these statements. Since they are not accidents, they are not occurrences. And since they're not occurrences, they are not covered by the initial coverage language of the policy under the homeowner's policies. And the court could stop its inquiry there again and grant summary judgment at Georgia Farm Bureau and be completely within the right to do so. If the court wanted to go on to that second question in our analytical framework and determine whether there's exclusions that apply, there are exclusions in the homeowner's policies that preclude coverage, even assuming that this is somehow bodily injury and somehow an occurrence. And those are the intentional act exclusion and the business exclusion. Like Your Honor mentioned before, the intentional act exclusion is more focused on bodily injury, which is expected or intended by the insured. So now we're going to the consequence side of things. And what's important here is that expected language. The courts have held that expected language is a question of what a reasonable person in that situation would expect to occur. Even if Mr. Wood did not intentionally or intend something to have damage, it's what a reasonable person would expect in that situation. And if we apply that reasonable person expectation, a reasonable person in Mr. Wood's shoes, with the following that Mr. Wood has on his Telegram account, could expect that people would be damaged by making these 19 defamatory statements that call them extortionists and criminals and ask for bar complaints to be filed against them. And so since that is something that can be expected, that falls within the definition of the intentional act exclusion. And it is precludes coverage under these homeowners policies. That would be another basis that this court could find that there's no coverage under the homeowners policies. The last exclusion for the homeowners policies is the business act exclusion. Policy provides that coverage is excluded for bodily injury arising out of or in connection with a business engaged in by Mr. Wood. Here, the courts have interpreted this arising out of language pretty broadly to say that if the cause of action had its origins in or grew out of or flown from an excluded act, then it is excluded under the policy. And that's reflected in both that arising out of language and that in connection with or in connecting with language. So here, the question is, did the defamatory statements relate or arise out of or was in connection with any business that was conducted by Mr. Wood? And the answer to that question is yes. Here, the defamatory statements that Mr. Wood makes are directly related to a March 17th, 2022 business settlement agreement he entered into with the WGW defendants. In his deposition, he states on page 48, he's asked, do you believe that there was in fact extortion committed by the WGW defendants? And Mr. Wood responds, I believe they extorted me into the agreement of March 17th. Mr. Wood later says, quote, "I believe that they extorted me into the March 17th agreement and I gave into it." That extortion is what he's talking about when he says these people are extortionists. That's directly related to a business settlement agreement, directly related to his business as L. Linwood PC. Since that is in connection with a business, it is excluded under the policy. So in sum, as it relates to the homeowners policies, the defamation allegations in the underlying complaint are not bodily injury, as defined by the policy. They are not an occurrence because they're not caused by an accident. And then going to the exclusion side, they are an expected injury by somebody who was in a reasonable position like Mr. Wood. And they are statements that directly flow out and arise out of his business settlement agreement that he engaged in with the WGW defendants. All of those are reasons why there is no coverage under the business auto, the homeowners policies. And the court should grant summary judgment to us based on that. Switching over to that personal auto policy, and this will be, I think, quite quick. The initial coverage language on that personal auto policy says that GFB will pay damages for bodily injury for which an insured becomes legally responsible because of an auto accident. In the underlying case, there's no allegation of an auto accident, so there's no coverage under this policy. And Mr. Wood actually agrees with that. You can look to his RFA response 53, where he admits there's no auto accident in the underlying case, so there's no coverage under this, which by extension would mean that there's no coverage under this personal auto policy. So Georgia Farm Bureau should be granted summary judgment as it relates to the personal auto policy on that too. And I've already touched on this already, but the homeowner policy 3125762 was canceled before any of the defamatory statements took place. The policy only provides coverage for things that took place within its policy period. These statements didn't take place within the policy period because it was already canceled. And you can see the Mr. Wood's response to the request for admissions 56, which shows that he also acknowledges that it was canceled. So overall, Your Honor, there is no coverage under these policies for Mr. Wood for the allegations made against him in the underlying complaint for defamation. It's not bodily injury. It's not an occurrence. It's excluded by the intentional act exclusion. It's excluded by the business exclusion, and the personal auto policy doesn't provide coverage because it's not an auto accident. Therefore, this court should grant Georgia Farm Bureau's motion for summary judgment on these coverage issues and determine that there is no coverage, and Georgia Farm Bureau has no duty to defend or indemnify Mr. Wood for the allegations of the underlying complaint. Thank you.
All right. Thank you, Mr. Woody. All right. I believe order of the heading would mean Ms. Brown would go next.
Good morning, Your Honor. Because I talk so loud, this is with the microphone. And just for the court reporter purpose, my name's Mylinda Brown, and I represent Nicole Wade Johnson.
Sorry, can you put the microphone back because I can't hear you anymore?
Okay, sorry. Can you hear me now? Sorry, Ms. Smith. Thank you for letting me know. My name's Mylinda Brown, and I represent Nicole Wade, Jonathan Grumberg, and Taylor Wilson, and I'm going to collectively refer to them as WGW. But as just for housekeeping purposes, it's important to note that their law firm is not a defendant in this matter. Your Honor, what's important for today and the analysis for the court is really understanding what the underlying lawsuit is in this case. I know that you are already familiar with the completely separate and other action that we have pending before Your Honor. That's the breach of contract and the fraud case. In that case, as you are well aware, it not only has my individual clients as plaintiffs, but it also has their law firm. And we have sued not only Mr. Wood individually, but his law firm as well as the McMurtry defendants. The federal defamation action, which is the underlying litigation that GFB is trying to exclude coverage for, is solely one count of defamation based on 19 distinct statements that happened way after we filed our lawsuit that's currently pending before Your Honor. It was only brought against Mr. Wood individually. His law firm was not sued in that case, and those cases do not overlap at all. They are separate and distinct. And we did that for a reason, because they don't relate to each other, and it doesn't make any sense to have a defamation action against one individual combined with a fraud and a conspiracy to commit fraud against all of these other defendants in the other case that's pending before your honor. The 4 policies at issue here, and I think plaintiff's counsel made it clear, there is no question. The automobile policy does not apply here. There obviously was not an automobile accident. And so I think that one, I'm not going to belabor that point at all. But the remaining 3 homeowners insurance policies, it only provides coverage for claims brought against an insured for damages because of bodily injury and caused by an occurrence. And it's important to know that all 3 of the homeowners policies, they provide the same definition for bodily injury and for occurrence. Obviously, plaintiff's counsel went over what bodily injury means, but it's sickness and disease and bodily harm. There is no dispute of any sort of material fact as to whether or not a defamation claim for purely emotional distress type of damages and reputational harm has no allegations of bodily injury, not only as a common sense, but based on the definition that's provided in the policy. Now, Mr. Woody only defined occurrence for the court as an accident. And the policy does start the definition of occurrence by saying, quote, accident, but it even goes further that, again, reaffirms that the coverage does not even apply here. The policy goes on to state in relevant part that an occurrence is defined as, quote, accident. And then it goes on, and the finishing part of the sentence says, which results during the policy period in bodily injury. And that is on page 7 of plaintiff's brief. And I think that's very important. So essentially, the 3 homeowners policies only provide coverage for bodily injuries that result from an accident causing bodily injuries. So there's 2 steps of having to prove bodily injury here to even at a threshold provide coverage. And Mr. Woody made clear to the court exactly what is required and how the inquiry needs to stop right at a threshold matter. He said the first step for the court to look at is, do the allegations in the underlying complaint, quote, fit within the coverage language? And if it does, the court can stop its inquiry there. And we agree. There is no bodily injury alleged in the defamation action, which are solely 19 distinct separate statements that Mr. Wood made on his personal social media account. And my clients have not alleged any type of physical injury, and I don't think anybody can dispute that. And so the analysis ends there, Your Honor. We don't even get to any of the exclusions because at a threshold level, there is no coverage to exclude. And so if there's no coverage to exclude, then we don't even need to look at the exclusions. And Your Honor, as you're aware, there is a separate action that's pending before you, but there is also another declaratory judgment action that involves another insurance company with another policy at issue.
Where is that pending?
It is pending in the Northern District.
And that's for the defamation claim?
It is a Scottsdale policy, and Scottsdale has sought declaratory judgment based on the federal case and the Fulton County case.
All right. And that's one that's, I guess, some kind of coverage for, say, the business?
I believe those are also, it's a personal umbrella policy.
Okay. And remind me exactly what that would generally cover.
So generally, umbrella policies ride on top of your homeowners and your vehicle insurance. The typical example is when you have one insurance company that provides coverage to an individual for their car, their home, and then the umbrella policy rides on top of it. And it's usually all the same companies. That's not what happened here, and I'm not sure why, but it appears that Georgia Farm Bureau provided the vehicle coverage and the homeowners coverage only. And then Scottsdale, Mr. Wood had a separate policy to provide umbrella excess coverage. And typically what's important in this case, related to the defamation action, is that that umbrella policies generally are the only policies that provide coverage for libel slander claims. And that's the reason why most people have those umbrella policies, because most homeowners policies now exclude any sort of publication, advertisement, any sort of libel, slander-esque type of claims because they're more focused on personal injuries.
So there's no intentional acts exclusion in the umbrella policy?
I'm not sure if there is an intentional act exclusion in that policy. There is some language, but that has not been litigated. And that's one of the issues that we have in this case, is that that the court runs the risk of having inconsistent verdicts in terms of how the language is defined vis-a-vis not only the defamation action, but whether or not the business exclusion piece of it applies, when this specific declaratory judgment action only has to do with the federal defamation case, and it has nothing to do with the other Fulton County lawsuit that's pending before your honor. And so we again don't even get to that point of whether or not these exclusions applies, and the policy language even confirms that. And on page 8 of Georgia Farm Bureau's brief, they even confirm that, Your Honor. And Georgia Farm Bureau said, quote, under the homeowner's policies, even if there is coverage provided by the initial coverage provision, coverage is excluded if bodily injury is either, and it goes on to talk about the exclusion. So again, the plain language of the policy, it's clear and unambiguous. There is not an ability to exclude something unless there is coverage. There's not even coverage here, so we don't even get to that. And in addition to the risk of inconsistent verdicts and determinations as to what language applies and what language does not apply with the exclusions, it's also very prejudicial to my clients to go ahead and make a determination as to those exclusions when the coverage is, the language is clear that coverage does not apply. In the event, though, Your Honor, that the court is inclined to consider these exclusions, it's even clear looking at the exclusions that they don't apply. Not only does the plaintiff have the burden to show that the exclusions apply, and that's the Hathaway versus American Empire Surplus Lines Insurance Company case, both exclusions that Georgia Farm Bureau is trying to allege here, they both start out with language that says that the exclusion apply for bodily injury if it's a business activity or if it was an intentional act. So again, even looking towards the exclusions, Your Honor, it's clear that these exclusions don't even apply in the first place because there's no bodily injury alleged here. And so I think that getting, even if the court were inclined to consider plaintiff's argument, which it should not, there is no application for any of these exclusions here to disclaim coverage because, again, both of these exclusions require bodily injury. Also, there is nothing in the record that, and we disputed this in terms of intent of whether or not a determination can be made as to the state of mind of Mr. Wood when he was making these statements. As Your Honor knows, whether or not a tortfeasor's intended something or not is a question that's usually reserved for the fact finder. But not only is that a longstanding Georgia principle, it's even more of a longstanding principle vis-a-vis defamation actions, because whether or not a statement was malicious is something that's left up to a jury question usually. And on page 4 of our brief, we gave a long amount of a string side of authority for those principles in Georgia. Now, the only other exclusion, the business exclusion, again, also requires bodily injury, but beyond that, it does not even apply to this situation. Mr. Wood, in his individual capacity on social media, most of the time, Your Honor, very, very late at night, making these statements has nothing to do with any sort of business happenings. These are individual statements he made against individuals that he happened to have a business relationship with. So if Your Honor were to accept plaintiff's argument, let's say, for example, I went over to Drew Beal's house. He's my business partner. I fall down his steps or something, and I get really injured to the extent that we have to go through insurance. Just because we're business partners, that could be excluded. That's essentially what they're arguing. They're taking something that happens to have a pre-existing relationship and trying to conflate it and say, just because these folks have a separate unrelated business dispute, that it should exclude coverage. Excuse me. But again, Your Honor, Your Honor doesn't even need to get that far of whether or not the exclusions apply, because it's clear that the unambiguous language in the policy, and based on Mr. Woody's own admissions to the court, that the court doesn't even go beyond step one. It's do the allegations in the federal defamation action, do they fit within the coverage language? And the answer is no, because the defamation action is not seeking damages for bodily injuries related out of an accident which caused bodily injury. So at the end of the day, that's where the court should stop its analysis. Thank you, Your Honor.
Ms. Brown. All right, Mr. Reyes.
Thank you, Your Honor. I have a question. We want to split Mr. Exum and I, so I can argue the response and he can argue what was filed last night regarding GFP's lack to file a motion to intervene. So it depends on whether Your Honor wants to hear from me first or Mr. Exum.
I'll leave it up to you. I'm like I said, I'm giving each party 20 minutes. So however you want to divide the time.
Thank you, sir. I'll go. Good morning, Ms. Smith. My name is Ibrahim Reyes, Ibrahim. Last name Reyes, Reyes, and I represent the defendant L. Linwood. Good morning, Your Honor. Again, we're here on a summary judgment filed by plaintiff Georgia Farm Bureau. And in order for Georgia Farm Bureau to prevail, it has to demonstrate that there's no genuine issue of material fact and that the undisputed facts viewed in the light most favorable to the non-moving party, that would be Mr. Wood, warrant judgment as a matter of law. Now, plaintiff Georgia Farm Bureau is incapable of demonstrating that there's no genuine issue of material fact, as its policy is ambiguous regarding whether bodily injury includes the WGW defendant's claims for emotional and mental distress resulting from the alleged defamation by Mr. Wood. It's also ambiguous as to whether occurrence includes the type of accidental harm, i.e. accident contemplated herein, particularly an insured Mr. Wood defending his name and reputation during a political campaign that he was running in South Carolina for chairmanship of the GOP in that state without any intention to defame third parties, in that case, WGW, only to defend himself from the attacks that he was receiving from the other candidate. And then he was sued for defamation. So whether defendant Wood intended to defend his name and reputation, or whether he intended to cause emotional distress to the WGW defendants,
So you have a lot of
it's a question for a jury.
you have a lot of hurdles that they've raised for you to clear, and it seems like the first one is whether the claim involved a bodily injury. What authority do you have that says defamation is considered a bodily injury?
The WGW plaintiffs in their case in chief claim that they suffered emotional and mental distress. Emotional and mental distress usually come under bodily injury in many personal injury cases. Where
Can you give me one? Because I think bodily injury is usually defined to include a physical aspect. And so what's the physical aspect of defamation?
I don't know. That's a question for the jury, Your Honor. When the plaintiffs describe what happened to them in their defamation and how they suffer emotional and mental distress, I don't know what type of emotional and mental distress they suffered. Some people suffer emotional and mental distress that involves bodily injury, and some people don't. Some people cry profusely. Some people get depressed. We don't know that. A jury needs to determine that, not the court. Now, what is certain is that the GFB policy does not define bodily injury to include or exclude things, and that's a power that they have had despite authority from case law. What the court has to decide here is whether the policy itself is ambiguous or unambiguous. And it is ambiguous, and it does not define these things in a manner that would allow anybody without a factual finding to make that determination.
So bodily injury is defined here as bodily harm, sickness or disease, right?
Sure.
And so is there any
I-
allegation in the complaint that they suffered bodily harm, sickness or disease?
Emotional injury can be considered to be bodily harm, and a jury would have to determine that. We don't know the degree of emotional harm. It really depends what they tell the jury when they testify of how bad it was.
All right. And so this isn't, the first time a bodily injury claim has been analyzed under our appellate precedent. How do you respond to the cases cited that where the Court of Appeals has said fairly definitively that bodily injury means physical harm and doesn't include slander?
Well, Judge, I have to, in that case, rely on Pan America Insurance Company versus Disabled American Veterans, 268 Georgia 564 at pages 565 and 566. The duty to defend is excused only when a complaint unambiguously excludes coverage under the policy, and thus the duty to defend exists if the claim potentially comes within the policy. Where the claim is one of potential coverage, doubt as to liability and insurer's duty to defend should be resolved in favor of the insured. GFB's homeowners policies do not unambiguously exclude coverage under the policy. They don't. They could have, but they did not. And if the facts alleged in the complaint even arguably bring the occurrence within the policy's coverage, the insurer has a duty to defend the action. And that's from the case that GFB, Georgia Farm Bureau, relies upon, which is the Summers case.
All right, so moving on to the next hurdle, how is this considered an accident? What happened?
Mr. Wood was a candidate for the chairmanship of the GOP in the state of South Carolina, and he was going up against Drew McKissick, who ended up winning that election. Drew McKissick pulled the WGW complaint against Mr. Wood and used it in that campaign to smear Mr. Wood. Mr. Wood's answer and affirmative defenses in that case had been sealed by the court, so Mr. Wood had to defend himself in the court of public opinion. He was defending himself from Drew McKissick. He was not trying to harm Ms. Wade, Mr. Grunberg, and Mr. Wilson. And there's case law on that distinguishes between an insured's intent and the consequences of his acts. And I can explain, even if the insured acts in an intentional manner, but does not intend or expect for his action to result in injury to another, then the exclusion does not apply.
Well, that's about the exclusion, right? We're talking about the definition of accident. And so you've given me a reason of why he felt the need to do it, almost kind of like a justification, kind of like a self-defense argument. But self-defense isn't an accident. It's something someone intentionally does to justify what they've done.
Their injury is accidental. Their alleged injury of having suffered emotional harm is accidental because Mr. Wood did not intend that. Mr. Wood intended to defend his name and reputation in South Carolina in a political campaign. That's all he intended.
So your position is that the definition of an intentional, whether under the exclusion or under the coverage aspects of this, both of those have to take into account the consequence.
The consequence, and that's what the case law in Georgia says, which is cited in our response.
All right, and what's the case that says that also covers the definitional aspects of things?
I'm sorry?
Like, what would be the case that you say you cite in your brief that covers accident in this respect?
Sure. Colonial Penn Insurance Company versus Hart, 162 Georgia Appellate 333 at page 335. It states, on the other hand, the mere knowledge and appreciation of a risk short of a substantial certainty is not the equivalent of intent. So Mr. Wood did not have the intent to injure the WGW plaintiffs, and that's what this case stands for. It further says an exclusion as to injury caused intentionally by the insured does not exclude coverage where there is an intentional act, but not an intentionally caused injury. And that's what happens here. Mr. Wood acted intentionally in saying the things he did say in South Carolina, defending his name and reputation from Drew McKissick. Did Mr. Wood intend to cause emotional harm to Wade, Grumberg, or Wilson? No, he wanted to win an election.
Right, and what I'm saying, what I think,
And that's the accidental occurrence.
that covers the exclusion. I think that's a.
And the occurrence, Your Honor,
That's
that
a
covers the
solid
accidental occurrence,
Okay,
and that it was accidental. What happened to these plaintiffs was accidental. What he did towards Drew McKissick was intentional. And that's a distinction. Now, a jury would have to determine whether his intent was intended at them. That's not something that we can resolve here today. Accordingly, as the law in Georgia requires, defendant Wood's intent is a question of fact for the jury to consider. Mr. Wood has testified that he intended to defend himself from a smear campaign in a South Carolina election. Now, if you want, Your Honor, I can now address the business aspect, the insured's business, because GFB says that Mr. Wood acted in a business capacity. He did not.
I think you got about 7 more minutes if you want
Yes,
to
sir.
turn it over.
Mr. Wood was not being willfully malicious, nor did he intend to harm Wade, Grumberg, and Wilson. And that is evidenced by the fact that he referred to them over 40 cases. And that's cited in in our response at pages 18 and 19. And as the Bates case states, in pertinent part, it's a case that we cite, without specific intent to injure, there will be coverage. And that relies on Southern Guarantee Insurance Company et al. Versus Saxon, 190 Georgia Ave, 652 at page 653. So in essence, there's no record evidence indicating that Mr. Wood intended to injure or harm the WGW defendants. That creates a material issue of fact, not a question of law. As his testimony is that he intended to defend his name and reputation, not to harm these people. The question of intent is for a jury to determine. So in conclusion, defendant Wood's homeowner's policies language and definition of bodily injury, occurrence, and accident are ambiguous. Do not state that emotional and mental distress are not bodily injuries, or that an accidental occurrence is not an accident or occurrence. And these ambiguities must be resolved in favor of Mr. Wood, the non-moving party. Similarly, the harm claimed by the WGW defendants was not caused by intentional acts of Mr. Wood directed at the WGW defendants, but rather by Mr. Wood's statements made while he defended himself from personal attacks during a political smear campaign in South Carolina, and not in his capacity as a lawyer, nor within the confines of the business of law. Hence, the homeowner's policies afford a defense and coverage, and the exclusions do not apply. Thank you, Judge, and now I can have Mr. Exum address the other part of the argument. Thank you.
Thank you, Mr. Reyes. Your Honor, may it please the court. Can you hear me all right, Madam Court Reporter? Okay. My name is John Exum. I'm here for defendant Mr. Wood. And I just want to clarify some potential confusion the court might have about the facility investments case. That I used that to cite the rule. I did not mean to posit that was a factual analog, and it had nothing, and why I used it had nothing to do with the reservation of rights letter. I know that Georgia Farm Bureau sent a reservation of rights, a universal reservation of rights letter.
But I guess procedurally, that's where I'm struggling to see how this case, which is kind of what you hang the argument on, fits into this metric of how does this case defeat a motion for summary judgment? Because that didn't seem to be an issue at all in that case.
It has to do with prejudice, and prejudice is defined by the Merriam-Webster as it can refer to injury or damage resulting from a judgment or an action. And if Your summary judgment is to if you decide to grant Georgia Farm Bureau summary judgment so that they are allowed to withdraw their litigation defense coverage, that would prejudice Mr. Wood. They've been in the case for a year and a half now, since May 20th, 2022, at least.
Can you give me a case where, let's say it was prejudicial, that meant motion for summary judgment shouldn't be granted?
Well,
No doubt they've been in it for a long time and you're deep into the litigation. But I didn't see this case as saying just because it's prejudicial potentially or harmful or just inconvenient that's going to mean they don't have a right to a declaratory judgment.
Well, the direct answer to your question is no, I don't have a case on what prejudice is, but the point is that this case gave what it described was their duty under the law to avoid to prevent the case from going into default and avoid the possibility of prejudice, and that includes seeking a stay, which they nominally did, but they did not follow. They did not take the necessary steps as called for in that case, which has has a green plus for LexisNexis is shepherding signals. It's good law in that facility investments case. So it hasn't been overturned. It's good law. And that's why I was doing it. And I was just saying that what they failed to do was that they failed to follow the local court rules and the federal rules of civil procedure, which applied in the federal court in which they sought to stay. In that federal court, they were supposed to state the grounds for their motion to stay. They didn't do that. They just gave a 2-page, hey, we want to stay this. They didn't have the standing. They're required to get standing. To get standing, they have to get a motion to intervene.
Did Judge Brown file an order in result, or was it just a docket entry when he denied the motion for stay? I didn't see that attached as an exhibit.
It is. It's on page 4 of 7 in Exhibit B, Your Honor.
Okay.
It was on October 13th of 2022. He gave a docket entry order only.
And did it say anything other than denied?
Well, I'll get to that exhibit. Let me get with you. Thank you. So it just says, let's see. It says, I'll read it to you. It says, order by docket entry only. The court denies Georgia Farm Bureau Mutual Insurance Company's motion to stay for the reasons stated in plaintiff's opposition briefs, dockets 1925, ordered by Judge Michael L. Brown on October 13th, 2022.
All right. So the plaintiffs, meaning Ms. Brown's clients, filed a motion in opposition. And in that motion for opposition, did they mention that, well, Georgia Farm Bureau doesn't have standing and that's why you should deny the motion for stay?
They did say that Georgia Farm Bureau didn't have standing. That is one of the things they said, yes.
And
they even used some of my cases.
Okay.
Well, and vice versa, yeah. The crib is yours, yes. The crib is yours, yes.
All right.
Sorry.
All right, fair enough. So it could very well be the case. I guess this is what I keep coming back to is, let's say you have a valid complaint that maybe Georgia Farm Bureau should have fought harder or done more to get a stay. I still am not seeing the next link where that denies them the ability to say we still want a declaratory judgment and to assert what we think the contract says. Well,
the way I think of it is that following the court rules is necessary, and they have to take necessary steps, and they didn't follow the court rules. So their filing of that motion to stay where they lack standing and didn't seem to account at all for the applicable rules, Federal Rule 7, Local Court Rule 7, that suggested they did not take the necessary steps. So it's tantamount to not really filing a motion at all.
If someone had a complaint about how their insurance company had handled litigation or failed to do something or other, would that create a separate cause of action or something that could be pursued?
Could you repeat the question? I'm sorry, Your Honor.
So outside of this context, is there a separate cause of action that someone could pursue against their insurance company for essentially if they had a legal malpractice claim saying they didn't represent me well enough or they didn't follow certain steps like this, would that create a separate cause of action?
I'll have to think about that one. I suppose I don't really know.
Right. So even if a declaratory judgment is entered here, if Mr. Wood feels that he has a remedy or a cause of action, that's not foreclosed if this motion to stay was deficient in some way. Potentially.
Again, I don't want to shoot from the hip, Your Honor.
Sure. Okay. What else did you want to share?
Well, I just wanted to clarify any potential confusions. I did file out last night, and I wanted to make my points on the supplemental filing.
All right.
Thank you, sir. Didn't mean to talk over you. My bad.
Not at all. Just in the interest of clarity, Mr. Woody, anything you want to respond just directly on that point? Why do you think this motion to stay was defective, and how you think that impacts the process?
Your Honor, I don't think I don't believe it was defective. I don't think it impacts the process. It's before this court. I'm gonna step up here. I think my mic doesn't work over there. Your Honor, I think the rule that's articulated in the Richmond case doesn't apply because there's no evidence in the record to show that Mr. Wood objected to being defended under reservation of rights. That rule only applies, and the court's kind of articulated it in a certain way it has, to cases where someone has objected to being defended under reservation rights. There's no evidence of that in the record, and it seems that Mr. Wood has agreed to be defended under reservation of rights. He got the letter, and 2 days later, he signed on to a defensive pleading with the attorney appointed by Georgia Farm Bureau. So I'm not sure if that rule even applies. Assuming that it does, I don't believe that the motion stayed was defective in terms of what it was required under that rule that Richmond says. It just says seek a stay. Georgia Farm Bureau sought a stay. They filed it. They considered what was going on. They considered the law that controls the Northern District of Georgia.
Well, I mean, apparently the judge over there agreed that you didn't have standing, or that you should have filed some kind of motion in that regard.
Your Honor, there are several reasons, and when the court says for the reasons said in plaintiff's exhibit, there are several reasons included in that, and one of those reasons, besides maybe something about following the local rules, which says that the order may be denied, doesn't mean it will be denied, was plaintiff's argument that, and plaintiff, I should say, the WGW defendants, that federal courts are not going to stay their own cases pending the outcome of a state law case. And that's pretty much been the general rule in the Northern District for years. To try to conjure up law that doesn't exist.
Is that just kind of the custom and practice, or is that actually written down?
It's written in the statute, and the case law over time develops. And I think a lot of the case law cited in the WGW's response to Georgia Farm Bureau's motion to stay in that federal case shows that it's not going to prevail. Federal courts are going to do what federal courts do, as we imagine they're going to keep going. They have a tighter deadline sometimes in some state courts. They're going to truck on through and not stay their own case pending the outcome of a state law case. But another thing, Your Honor, while we're talking about the prejudice aspect in that test, the way that supplemental brief is written makes it sound like if the court were to grant Georgia Farm Bureau's motion for summary judgment, Mr. Wood would have to go out and find his new counsel when he's just left out to dry. I don't think that's true in this case. Mr. Reyes has been Mr. Wood's attorney in the underlying case since the beginning. He's been involved.
Not in this case.
Is the filing? You can go back to the filings, Your Honor. You can go back to the underlying case and see that Mr. Reyes's name is on many of the answers and early pleadings in that case. He's been involved, even if it's just as a name. According to the documents filed, he's involved in that underlying case. He'd still be Mr. Lynn Wood's attorney in the underlying case where the court would grant summary judgment in this case and allow us to withdraw a defense. And Your Honor, I'm not going to try to do an entire rebuttal if the court doesn't want me to.
No, I don't think we need to go down that road.
I don't want to try to waste too
All
much
right, thank you,
time.
sir.
Thank you, Your Honor.
And I'm just curious with the federal case. It sounds like y'all are still waiting on a motion for summary judgment hearing.
Yes, Your Honor.
Yes, sir.
And do you want me to briefly explain what all three positions were in the?
I don't think that's necessary.
Okay.
So if there's with that, we'll take it under advisement and we'll go off the record, and we'll be done. I would say, just as a matter of case management, I would check in, since we've got some of the parties here on the other civil claim we have pending. The 6-month scheduling order expires in February, right? At this point, are there any expectations of extensions to be sought? I'm just kind of checking in on discovery. Are there depositions that's still remaining
Yes, Your
Yes,
Honor. We have been working very diligently and cordially, might I add, in really getting everybody scheduled. And, now that the Mercury defendants have been added, we have even more lawyers involved because the clients are lawyers and then they have counsel as well. And so we have been exchanging dates, and we have several scheduled.
We have several depots in January, Your Honor.
Okay.
And so
Now-
there's a small potential.
But there's a potential that some of those testimonies will bring in other people that will then need to depose. So yeah, it does seem that it may need to be extended.
Okay. Well, we'll obviously if it's a joint request, send that over to us and just put in, what it is, how much time you need and what it is exactly, you're going to do next, and we'll take it from there. But the hope would be is that we're able to start talking about dispositive motions by the summer at the latest, if any are to be filed.
Right.
Okay. All right. Anything else you think we ought to, again, we're just kind of off the record case management purposes, Mr. Woody, feel free to take off. Anything else we need to talk about while we're out here?
Happy holidays and Merry Christmas.
All right. Same to y'all.
Merry Christmas.
Happy
All right.
holidays.
Take care.
And Mr. Thank you so much for all of your
Thank
help
you.
today.
Thank you all
so much.
And whoever else was
Yeah.
involved back there in getting the court